There is no relief for former Delhi Deputy Chief Minister Manish Sisodia, who's been into the custody of the Enforcement Directorate since February this year. After a setback from the Delhi High Court, which denied him bail on similar grounds, accepting the arguments made by CBI and Enforcement Directorate, even from the Apex Court, the much anticipated relief that Sisodia and his lawyers wanted, that has been denied to him. What does this mean? It means that all possible avenues of securing your liberty or getting a bail under the present case at this point seem exhausted. It is only after 6 months, if the trial proceeds very slowly, then Manish Sisodia can go to the Supreme Court and once again argue for a bail. But what are the key reasons why the Supreme Court has thought it fit? A court that has often reiterated that bail is the rule and jail is the exception, the same court thought it fit that Manish Sisodia should not be granted bail. Number one, under the PMLA offences, which means Prevention of Money Laundering Act, under these offences, the ground for securing a bail is far more stringent. The court, including the High Court and the Supreme Court, while exercising their powers, have to come to a prima facie conclusion that the accused did not commit an offence. This threshold is far higher than the ordinary offences under the CRPC. That's point number one. Secondly, there are various offences or arguments that were advanced by the CBI in their charge sheet. There's one particular point that was mentioned by Justice Sanjiv in the pronouncement of the order, a brief 3-sentence point that he made when this order was pronounced in the early morning at the court today, at the Supreme Court today. And he said that roughly 338 crore rupees, those alleged kickbacks, they seem to be the reason where the Supreme Court thinks that the CBI is slowly establishing their case. Now, there's one point I want to reiterate, that in that order, the court lists out various portions of the CBI charge sheet, the accusations that have been made, and says it towards the end that on the basis of the aforesaid discussion, the court thinks that a bail should not be granted. It means that the arguments that were advanced by the Central Bureau of Investigation and by the Enforcement Directorate before the Supreme Court, that this money trail to a certain extent has been established, prima facie there are indications there was some guilt or some complicity on part of Manish Sisodia. He was allegedly one of the key mastermind who was responsible for this kind of scam that had happened. Prima facie, the court accepts this argument of the CBI that there is an offence that was committed. In some way, Manish Sisodia was involved and he should be investigated into that matter. But that is very different from the Supreme Court coming to a conclusion that this money trail is established. That is not conclusively established at this point. What is rather established is that CBI does have a strong case and a footing to move forward. Enforcement Directorate has a strong case and a footing to move forward. It is only in the circumstance when after 6 months the trial has not proceeded or the pace of the trial is very slow, the court can once again take up the matter and decide whether a bail needs to be granted or not. But as of now, all the remedies lie exhausted for the former Delhi Deputy Chief Minister Manish Sisodia. In fact, there was an interesting argument made that even Aam Aadmi Party, the political entity, should be made an accused in this case. Time will tell to what extent that's possible, but for now, no relief for Manish Sisodia.